This is appellant's first suspension of sentence, Lordship. Appellant is convicted for offence under section 302 and 34 of IPC, Lordship.
Sole appellant.
No, Lordship, there are three accused persons in this case.
Today we are concerned with
Kamlesh.
what is the story?
Yes, Lordship. Para number 2, Lordship.
Yes.
अभियोजन के प्रकरण संक्षेप में इस प्रकार है कि दिनांक 6/3/2013 को बोहानी करेली डाउन ट्रैक पर एक अज्ञात व्यक्ति की डेड बॉडी पड़ी होने की सूचना प्राप्त हुई, जिस पर सोयनसो उप स्टेशन अधीक्षक द्वारा रामप्रसाद की एक लिखित तहरीर थाना करेली में पेश करने के संबंध में दी, जिस पर रामप्रसाद द्वारा उक्त लिखित तहरीर थाना करेली में दी, जिस पर थाना करेली में मर्ग इंटीमेशन क्रमांक सोयनसो जांच कार्रवाई प्रारंभ की गई। अनुसंधान के दौरान मृतक की नक्शा पंचायतनामा प्रदर्श सोयनसो की कार्रवाई कर साक्षीगण को नोटिस एग्जिबिट P30 जारी किया गया। मृतक के शव का शव परीक्षण हेतु आवेदन सोयनसो भेजा गया। अनुसंधान के दौरान घटनास्थल का मौका नक्शा तैयार किया गया। साक्षीगण के कथन लेखबद्ध किए गए। पहचान कार्रवाई एग्जिबिट P1 की गई। अनुसंधान के दौरान पाया गया कि पूर्व रंजिश के कारण बंटी, कमलेश एवं रज्जू ने एक राय होकर गोविंद के साथ मारपीट कर चोट पहुंचाकर गोविंद को ट्रेन की पटरी में फेंका। अनुसंधान के दौरान अभियुक्त गण के विरुद्ध थाना करेली में अपराध क्रमांक सोयनसो 302, 201, 120B 34 IPC की प्रथम सूचना एग्जिबिट P21 लेकर अभियुक्त सोयनसो को गिरफ्तार कर गिरफ्तारी पंचनामा तैयार किया गया। Lordship, in this case, actually the incident is alleged that the mother of the wife of the deceased lodged the report that there was a earlier enmity between the present appellant Kamlesh with the deceased Govind, and due to that enmity, this present appellant hired two persons, the two other co-accused persons, and they were last seen with the deceased, and they had taken the deceased to some place and they killed him. This is the actual prosecution story is this, Lordship. Now, so far as present appellant Kamlesh is concerned, the allegation against the present appellant is this, that he hired two persons and had given 20,000 rupees, and the remaining 80,000 was given after the incident, Lordship. Now, Lordship, the chain by which I was connected with the offense, Lordship, that is only the mobile calling details, Lordship, and for that, for one moment, Lordship may kind enough to kindly see para 22 of the impugned judgment.
Court has reduced in writing the circumstances.
Three circumstances were there: last seen, incriminating material, and motive. For
Yes.
last seen, there were two persons who were last seen with the deceased. They were the co-accused two persons. So far as incriminating material, nothing has been seized from the possession of the applicant because he has been only implicated that he called these two persons. Number 3, motive. Motive has been established by the court in paragraph number 34 onward. In paragraph number 34 that there was motive because after 10 to 12 days earlier there was a dispute between them, and then the present appellant told the deceased that I will kill you, and that was the motive created by the prosecution, Lordship. Now, Lordship, if the seized articles which were seized from my possession is the one mobile phone, Lordship, and that mobile phone too, it was alleged that there were two SIMs, and the prosecution comes with the story that one SIM I have thrown somewhere, and the one SIM which I was having, that is of number 433, last three numbers are 433, Lordship. Now this mobile phone and the SIM was sent to to IT cell, and the important witnesses in the,
Slipper, blood-stained slipper.
no, I
is
was not
clear.
at all in the place of incident. For the FSL and all these are concerned with other two co-accused persons. For me, the only allegation is that I hired the co-accused persons to murder the deceased.
What is the basis for that call details?
Only the call detail. And now I
Call
dispute.
details are established.
Now I am coming to that, Lordship. The two witnesses are most important witnesses are there, PW 22, PW 23 and 24. First thing which the prosecution failed to prove, and all these witnesses nowhere says that the mobile phone which was seized from my possession, the IEMI number of that mobile phone was having that SIM in that phone. That evidence is totally missing in the entire evidence of PW 23, 24 and 25. May I kindly read the evidence, Lordship? PW 24 Lord, 23 Lordship, PW 23.
Yes. Three. Yes.
May I Lordship? दिनांक 2/5/13 को कार्यालय पुलिस अधीक्षक सोएंसो के पत्र क्रमांक सोएंसो के द्वारा थाना करेली के अपराध क्रमांक सोएंसो में मोबाइल नंबर this first number Lordship 9977618433 this was seized from me को दिनांक 25/2/2013 से 20/3/13 तक की कॉल डिटेल को एवं कैफ की सत्यापित प्रति प्रदान करने के संबंध में हमारे कार्यालय को पत्र प्राप्त हुआ जो एग्जिबिट P57 है। उक्त पत्र के प्राप्त होने के पश्चात हमारे कार्यालय के तत्कालीन नोडल ऑफिसर सोएंसो के साथ मैंने भी कार्य किया है, इस कारण उनके हस्ताक्षर भली भांति पहचानता हूं। वर्तमान में किसी अन्य विभाग में चले गए हैं। द रिलेवेंट पार्टीज 4 लाइन्स लॉर्डशिप, लास्ट 4 लाइन्स। हमारे कार्यालय के द्वारा 2/5/2013 को मोबाइल नंबर सोएंसो की 25/2/13 से 20/3/13 तक की कॉल डिटेल जो 13 पृष्ठों में है, एग्जिबिट P58 है। उपरोक्त नंबर का कस्टमर एप्लीकेशन फॉर्म जो कि 8 पृष्ठों में है, एग्जिबिट P59 है, जिसमें हमारे कार्यालय की सील लगी एवं तत्कालीन नोडल अधिकारी राजेश सिंह जी के हस्ताक्षर हैं। नाउ लॉर्डशिप द क्रॉस एग्जामिनेशन पैरा नंबर 3। यह सही है कि प्रदर्श 58 में कॉल डिटेल रिपोर्ट में मोबाइल नंबर सोएंसो के नाम पर है, किसके नाम पर है उसका नाम उल्लेख नहीं है। साक्षी ने स्वतः कहा कि कैफिए में उसका नाम उल्लेख रहता है। यह सही है कि मोबाइल नंबर दिस इज माय मोबाइल नंबर सोएंसो कैफिए रिपोर्ट के अनुसार किशोरी लाल के नाम पर है। यह सही है कि मोबाइल नंबर सोएंसो कैफिए रिपोर्ट में गोविंद के नाम से अंकित है। These are the persons not the accused in the case. And for establishing the fact that these SIMs were used for calling and the mobile phone which was seized from my possession, the prosecution must establish the fact that IMI number was used this SIM was used in that IMI number for making the calls. Now the similar lordship is PW 24 इन पैरा 6। मैं पुलिस विभाग में साइबर सेल में हूं। यह कहना सही है कि मेरे द्वारा प्रदर्शित दस्तावेज कॉल डिटेल लोकेशन सो एग्जिबिट 66 to 76 77 में मोबाइल नंबर जो कंपनी के हैं उस कंपनी के किसी अधिकारी के हस्ताक्षर नहीं है। यह कहना सही है कि उक्त दस्तावेजों पर मेरे भी हस्ताक्षर नहीं है एवं मेरे भी हस्ताक्षर नहीं है कि कॉल डिटेल मैंने स्वयं नहीं निकाली थी। That was neither signed by the department, telephone department, by the Vodafone and Airtel, the both SIMs were used. There is no sign pertaining to that, lordship. Now, lordship, again PW 25, para number 3.
एनिमोसिटी थी आपकी, इसके बारे में पहले आपके खिलाफ रिपोर्ट की थी डिजीज ने।
वो जो है वो भी एग्जिबिट हुआ है लॉर्डशिप। डिजीज ने रिपोर्ट नहीं की थी, वो हमने रिपोर्ट की थी। डिजीज की रिपोर्ट हमने की थी, उसमें रोजनामचा लगा हुआ है लॉर्डशिप। दैट इज वो अपराध कायम भी नहीं हुआ था, दैट रोजनामचा इसमें लगा हुआ है।
कुछ एनिमिटी थी पहले उससे?
वो एनिमिटी उतना ही है, उसमें कोई ऑफेंस भी रजिस्टर नहीं हुआ था, कुछ भी नहीं था। ये था कि दारू पी के दोनों लड़ रहे थे, वो 20-25 दिन पहले के। उसी वजह से उनका कहना है कि हमें शक है कि इसने कमलेश ने इसमें इनको दोनों को हायर करके ये कि ना ही कोई अकाउंट ट्रांजेक्शन है कि हमने अकाउंट से कोई पेमेंट किया हो। कमलेश एक छोटा सा गांव का विलेजर है, उसने कहीं से कोई ट्रांजैक्शन नहीं है, कुछ भी नहीं है। और जो कॉल डिटेल है, कॉल डिटेल में भी कहीं ये प्रूफ नहीं है कि ये मोबाइल फोन हमने, अच्छा जो हमारा 313 स्टेटमेंट हुआ है उसमें भी हमने ये स्पेसिफिक, वी हैव टेकन अ स्पेसिफिक डिफेंस लॉर्डशिप दैट आई हैव नॉट यूज्ड दैट सिम और दैट फोन, whoever might have used my telephone, that clear statement has been taken. 313 statement is there, lordship. He had taken the defense, lordship. Nothing is there to connect me with the present crime. And whatever motive is both-sided sword, lordship. That may also be possible that they might have been implicating me because there was an enmity with them. Other than that, there is no connecting material, lordship. I am in custody since the date of judgment, and earlier also I was in custody. During some time I was in bail. And para 34 of the judgment, lordship. That is the only part, para 34, that is the only part by which I have been implicated, lordship.
SIM was recovered from you.
That is one SIM bearing number 433, last number, that was recovered from me. It was a dual mobile set which was seized from both the seizure and memorandum witnesses. Both the witnesses have turned hostile. They have not supported the case of the prosecution at all so far as the present applicant and one more accused is concerned.
But IO must have proved it. IO must have proved it, the
For
recovery.
that, I have read the evidences of the IT department, Lordship. They have not proved that what mobile has been seized from my possession, whether that SIM was used from that mobile for calling the person or not. That is why IEMI number was mentioned. And there is no in the entire
That
prosecution.
mobile must be carrying the same SIM, na? The SIM which is recovered from you.
That is not proved.
Hmm.
That is not
From you,
proved.
what is recovered, SIM or mobile?
Mobile and SIM.
Both.
They are saying, yes, as per the seizure memo may kindly be seen for a moment. Exhibit P17 is the seizure memo. P15, they have seized one mobile and the SIM. And for another SIM, it is a dual SIM mobile phone. Another SIM, the story was developed कि जो दूसरी SIM थी वो मैंने बर्मान की नदी में फेंक दिया. And if the mobile phone was seized, then the evidence must come on record that that IEMI number was used for the purpose of calling. Only by recovering a
The finding in para 34, they say that court has said कि mobile and SIM आरोपी बंटी और कमलेश से जब्त हुई है.
जब्त हुई है मोबाइल एंड सिम बोथ.
और उस सिम से
और वो उससे फिर उन्होंने बता दिया वो जो सिम में कंट्राडिक्शन है ना लॉर्डशिप, वो दैट इज व्हाट आई एम सेइंग. PW23 द सिम कमलेश के नाम से ना होकर गोविंद के नाम से.
पर जब तो आपसे हुई है ना, वो नाम किसी और का होगा.
सीजर विटनेस इज टर्न होस्टाइल. Caesar had witnessed
That
for
is a normal
he had not
process.
turned completely hostile. For he is not a complete. The lordship may kindly see for a moment. Caesar witnesses.
But IO must have proved na, that this SIM is recovered from you.
IU is I am reading that also.
So why his statement should be disbelieved? The money was also recovered from you.
Yes, lordship.
Money was also recovered from
No,
those two,
no money
those
was-
two persons. It was recovered from those two persons.
Money was recovered for that money, lordship. There is no proof pertaining to that fact that I have given the money to them. Money, they are the persons, they may have money in their homes, but that money was not given to them. There is no evidence pertaining to that, lordship. As CSP Aadhar Tal was examined as PW12. And CSP Aadhar Tal in para 14, he is saying that Kamlesh Kirar के मोबाइल नंबर so and so तथा CSP आधार ताल is PW12. प्रकरण में आरोपी कमलेश किरार के मोबाइल नंबर so and so तथा so and so. He is saying that he seized both the mobile SIMs, but only one SIM was seized from the possession of the applicant as per the case of the prosecution itself. His own statement is not correct, Lordship. This is in his chief he is saying. And another retired investigating officer, he has not stated anything pertaining to the seizure and memorandum, lordship. And he has not stated anything. Vinod Tiwari, PW15, he is completely silent about the seizure memo from the present applicant.
Government.
Lordship, first of all, I have mentioned on the applicant number 2, 9/11/2022, the bail is dismissed on merit.
इनकी
Applicant number 2.
नहीं, वो तो वो लोग हैं जो लास्ट सीन
Yes,
देखे गए.
Lordship. There the person is the last in together that the identified by the Zirabai and Sita.
हाँ, वो तो उनका लास्ट, इनका तो लास्ट सीन है नहीं.
Yes, Lordship. But the important, Lordship, paragraph number 34. Lordship, we insisted by 2.5 many time. May I read, Lordship? Paragraph number 34. अभियोजन की ओर से अभियोजन साक्षी दिलीप प्रधान एवं श्रीकांत की साक्ष्य परीक्षण न्यायालय में कराया गया. उन्होंने थाना करेली के अपराध क्रमांक 800 मोबाइल नंबर 100 की कॉल डिटेल सत्यापित प्रति चाहे जाने पर उन नंबरों की कॉल डिटेल प्रदर्शित 54 एवं 58 के अनुसार पुलिस अधीक्षक नरसिंहपुर को प्रेषित किए जाने वाले साक्ष्य संबंधी साक्ष्य दिए. उक्त अभियोजन साक्षीगण के बचाव पक्ष की ओर से सुझाव दिए जाने पर कि प्रदर्श 54 एवं प्रदर्श 58 की सिम अशोक कुमार एवं किशोरी के नाम पर है, जिसे साक्षीगण ने स्वीकार किया. भले ही इन साक्षियों द्वारा उक्त सुझाव को स्वीकार किया हो, परंतु उक्त मोबाइल और सिम आरोपी बंटी एवं कमलेश से जब्त हुए हैं. आरोपी के पास उक्त मोबाइल एवं सिम कैसे आई और कैसे प्राप्त की, इस संबंध में बचाव पक्ष की ओर से अपने पक्ष समर्थन में कोई साक्ष्य न्यायालय में नहीं कराई. जिससे यह स्पष्ट हो सके कि घटना के समय उक्त मोबाइल और सिम का उपयोग आरोपी गण के मध्य वार्तालाप में नहीं हुआ। ऐसी स्थिति में आरोपी गण ने उक्त सिम मोबाइल जब्त किए जाना और उक्त नंबरों पर आरोपी गण के मध्य वार्तालाप होना सक्षम आता है। ऐसी स्थिति में अभियोजन साक्षी दिलीप प्रधान एंड द्वारा सुझाव स्वीकार किए जाने से इन परिस्थितियों में साक्ष्य पर कोई विपरीत प्रभाव नहीं पड़ता। अतः अभियोजन साक्षी दिलीप प्रधान एवं श्रीकांत
The only evidence is that this SIM was used to talk with these other two persons, Bunty and Raju.
लॉर्डशिप
But what is the
बट लॉर्डशिप
tower location? What is
Sorry.
the nature of discussion? That
नो डिस्कशन इज नॉट
only
बट
duration is there.
यस लॉर्डशिप
Only duration is there, not
यस लॉर्डशिप
not.
before the incident the duration but lordship may I am not pursue the entire call detail उसमें IMI नंबर इस मेंशन रहता है जो कॉल डिटेल आती है CDR आती है वो किस मोबाइल से यूज किया जाएगा उसमें IMI नंबर जो है वो सिम के साथ कनेक्टेड होकर के आता है कि ये सिम इस मोबाइल नंबर से चल रही हो। कैफे रिपोर्ट निकलती है उसमें उसका IMI नंबर मेंशन रहता है। जो CDR रिपोर्ट आती है उसमें IMI नंबर मेंशन रहता है कि ये पर्टिकुलर मोबाइल से वो पर्टिकुलर सिम चल रही है। उसका लोकेशन टावर भी आइडेंटिफाई होता है उसी
वो
से।
तो आई नहीं है एविडेंस कुछ।
आई एम नॉट प्रेजेंट ऑन द रिकॉर्ड।
टावर लोकेशन का कोई evidence?
टावर लोकेशन का नहीं है और केस भी टावर लोकेशन का नहीं है।
नो मैं आई जस्ट पॉइंटेड आउट कि जो IMI जो मोबाइल है उससे सिम जो चलती है वो उसका IMI नंबर मेंशन रहता है उसमें। देन लॉर्डशिप सेकेंडरी है द मेमोरेंडम ऑफ द को एक्यूज लॉर्डशिप द मनी इज रिकवर ऑन पैराग्राफ नंबर 40 लॉर्डशिप।
वो इनके as against appellant can it be used? There is no other independent witness to connect that money was given by the appellant.
नो
Yes,
Whether their memorandum can be used against the appellant.
only on the recovery. Then the previous enmities are there lordship.
Some money is recovered from XY,
Yes,
but this was given by Z. What is the material for that?
there is missing that but the cash is recovered. What is the intention? ये तो इन्हीं के साथ के को एक्यूज है तो वे इनके खिलाफ क्यों बोलेंगे कि इन्होंने पैसा दिए मेरे को। इनके तो इनके साथ कोई एनिमिटी नहीं है। एनिमिटी तो डिजीज के साथ थी। अपने ही साथी को फंसाने के लिए क्यों बोलेंगे इसने मेरे को पैसे दिए।
That's all.
Then lordship important person is Kaushal Singh Rai, investigation officer PW12. On the basis of the memo he is recovered the amount lordship. The 68,000 rupees is recovered.
MS Sindhu Pandey for the appellant number 3.
Number
कमलेश
Kamlesh 3 lordship.
Appellant number 3 is such and such for the state. Hard on IA number 5975 of 23 for suspension of sentence arising out of such and such. Learned counsel for appellant submits that the case of prosecution is based on circumstantial evidence that as per prosecution story, the appellant had animosity, previous animosity with disease का नाम क्या है?
गोविंद
Govind.
With disease Govind. Because of that, he hired other two accused persons, namely Bunty and Raju, and gave them advance to murder Govind. But after the execution of said task, remaining amount was required to be given. Next May. Learned counsel for appellant by placing reliance on para 22 of the judgment submits that the conviction is recorded on the basis of 3 factors, namely dash number 1, last seen theory, number 2, incriminating article, number 3, motive. It is urged that the last seen theory, the finding relating to last seen theory given by court below relates to accused Bunty and Raju, and no finding in this regard is given against the appellant. Next paragraph. So far, motive is concerned, it is submitted that no doubt a Rose Namcha was placed on record to show that appellant lodged a report against Govind, bracket में deceased, but that alone, but no, but it was not reduced in writing, but it was not it was not translated in the shape of a regular criminal case, etc. Dot animosity is a double-edged sword, SWORD, and therefore, in absence of any clinching evidence, comma, only on the basis of previous enmity, comma, motive cannot be attributed. Next, mein, so far incriminating article is concerned, comma, a mobile phone is allegedly recovered from the appellant and Bunty. Dot in the cross examination of PW 23, he candidly admitted that said mobile phone is in the name of Kishori Lal. Mobile phone ki SIM,
Kishori Lal.
mobile ki SIM,
The
SIM.
mobile number SIM.
SIM लिखिएगा ना. SIM is in the name of one Kishori Lal. Dot criticizing the finding given in para 34 of judgment, it is submitted that it could not be established that the tower location of appellant was near the place of incident. Dot the nature of discussion is not on record, and therefore merely because there was some discussion of the conversation as between Bunty and Kamlesh as per the SIM, comma, it is not sufficient to affirm the conviction. Next, may the final hearing of this appeal of 22 will take time. Not the chain of circumstances is not complete, and therefore remaining jail sentence may be suspended. Shri A.N. Gupta supported the findings given in para 34 of the judgment. Dot in the aforesaid backdrop and without expressing any conclusive opinion on merits, we deem it proper to suspend the remaining jail sentence of appellant number 3. 50,000 की जमानत कर दीजिए. ट्रायल कोर्ट गाडरवाड़ा डिस्ट्रिक्ट नरसिंहपुर के सामने 3rd October and further dates.
Highly obliged.